attention, please? The United States Constitution is a remarkably resilient document. It's withstood over a century and a half of pressure from such diverse sources as William O. Douglas and Strom Thurmond. The issue before us today is whether it can survive the pressure of being compressed into 7 hours. I think it probably cannot. And my purpose here is not to digest and regurgitate the Constitution, but to do what I can to enable you to pass the bar. I found that the area of constitutional law and criminal procedure does not lend itself very well to an extensive use of past bar exam questions as a method of conveying the material or reviewing it. So you'll find me using far less questions than you've encountered in other subjects. Turning to the outline, we begin with the judicial power, an area essentially untouched by the bar examiners in the past 10 years. That indicates, I think, the amount of attention that you should pay to it in reviewing for the bar. Briefly, however, Article 3, Section 2 defines the contours of the federal judicial power, and Article 3, Section 1 vests that power in the Supreme Court and such lower courts as Congress chooses to establish. The Supreme Court's appellate jurisdiction, which is subject to congressional regulation, but probably not to congressional abolition, currently takes the form that's outlined in items 3 and 4 on pages 2 and 3 of your outline. And for purposes of the bar, you will not need to know anything beyond what appears in those 2 items. Unlike legislative courts established by Congress to implement its Article 1 powers, courts like the U.S. Tax Court, the Court of Claims, and the courts of the District of Columbia, courts that are established by Congress pursuant to Section 1 of Article 3, that is, the federal district courts, the United States Courts of Appeals, can only decide actual cases or controversies and are thus constitutionally subject to the basic restrictions outlined in item 6 on page 3 with respect to the United States Supreme Court. Before discussing those restrictions, I want to say a few words about the limits of the Supreme Court's power in reviewing state court decisions. And so I'll begin with item 5 on page 3, conditions for review of state court decisions in the Supreme Court. Technically speaking, the first 2 of those conditions, no independent state ground and exhaustion, are not statutory. It's only the third, final decision, that is a matter of statute. And so discussing that third first, the statutes governing the appellate jurisdiction of the court provide that the Supreme Court can review only a final decision by the highest available state court in a given case. Now that may be, and ordinarily is, the state Supreme Court, but on occasion it will be a state trial court if the question is one that the higher courts of that state lack jurisdiction to review. So it's possible for a case to reach the U.S. Supreme Court directly from what in effect is the lowest court of a state, when it's also the highest court that can review that kind of question. The decision must also be final. That is, there must remain nothing substantial for the lower courts of that state to do. The rights of the parties must be finally determined by the decision in order that it be reviewable by the Supreme Court. Probably the most important item in Section 5, conditions for review of state court decisions, is point A, no independent state ground. And that is really a corollary of the cases or controversies requirement. The Supreme Court, being an Article 3 court, cannot render purely advisory opinions, although occasionally it does so. Theoretically, it cannot render purely advisory opinions, opinions which do not alter the rights of the parties in the case. And therefore, since the Supreme Court's power to review state court decisions is limited to federal issues in those decisions, even if a state court decides a federal question in a manner that's plainly incorrect, the decision is not subject to reversal by the Supreme Court if the same result would be reached whether or not the federal question were decided that way. For example, a state court might decide that a given statute violates both the state Constitution and the Due Process Clause of the 14th Amendment to the United States Constitution. And even if the second holding is completely wrong, the Supreme Court has no power to review the first of those 2 decisions, namely that the statute violates the state Constitution, Therefore, even if the court were to disagree with the court below as to the second ground, the case would come out the same way, and it would be a purely abstract statement of the law for the court to grant certiorari in the case, hear argument, and then affirm the result below, saying, by the way, we disagree with the court below insofar as it said that the statute violates the federal Constitution. A decision of that kind is said to rest on an adequate and independent state ground. And the kind of state ground I've just described is a substantive state ground of decision. More common are procedural grounds of decision, and they ordinarily arise in the following context. A federal constitutional claim is set forth by a party in the state courts. The state courts refuse to decide that claim because of the manner in which it was presented. An objection, for example, may not have been made in a timely way at trial, or available administrative state remedies may not have been exhausted. Or for any of a number of procedural reasons, the state court may decide as a matter of state law that the federal claim is not properly presented to the state court. Now, if that decision of state law is defensible and does not represent something that the state court has obviously pulled out of a hat in order to circumvent the federal claim being asserted, there is again no basis for Supreme Court review. The procedural ground relied upon by the state court is called an adequate and independent state ground of decision, namely that as a matter of state law, the federal claim isn't really in the case. Now, of course, in order to prevent state courts from circumventing federal constitutional rights, the Supreme Court must have power to determine the adequacy of an asserted state ground. In a typical case, if a state court has said, as some state courts have, that we will not decide this federal question because we hold that from this day on, federal questions must be presented on a yellow as opposed to green paper, then that is obviously not an adequate state ground. There is no state interest in preserving that procedure, and particularly when it's a surprise to the litigant, when it does not represent an established state practice, the Supreme Court regards the ground as inadequate. And even in closer cases, a state ground of decision may be deemed inadequate. In the case of Henry versus Mississippi, probably the most important case in this area, in 1965, Henry had a Fourth Amendment claim that he sought to present to the Mississippi courts. But his counsel had objected to the introduction of evidence not at the moment the evidence was introduced. He had instead waited until the state had presented its case, and he had made the objection at the same time that he made a motion for a directed verdict. The state court said, we're not going to consider the objection to the evidence, it's too late. You should have made it when you introduced the evidence. And that was an established state rule. It was not simply a surprise that the state pulled on him as a means of avoiding his federal claim. Nonetheless, the U.S. Supreme Court held that the state interest in judicial economy and efficiency could be adequately served by considering the claim at the later time when it was made in connection with a motion for a directed verdict. It was not necessary as a matter of state policy, held the U.S. Supreme Court, that the claim be presented contemporaneously with the introduction of the evidence. Therefore, unless on remand there was some evidence that defendant's counsel had made a tactical decision to delay his objection, the state had to decide the federal issue. The supposed procedural reason for not doing so, the U.S. Supreme Court held, was inadequate. And if you do have a question on the bar in this area, it's more likely than not to revolve around the kind of case that I've just described in Henry v. Mississippi. Federal claim is presented to a state court. The state court refuses to decide it because of the way in which it was presented. The issue for the Supreme Court, before it can reach the merits of the alleged federal claim, is whether the state rule, which is invoked to avoid deciding the federal claim, serves a substantial state interest. If it does not, then it's invalid. But of course, Henry v. Mississippi also stands for the proposition the state does have a substantial interest in holding a defendant to tactical decisions made by his attorney. And so deliberate evasions of reasonable procedural requirements imposed by the state in almost all circumstances will be an adequate state ground for refusing to decide the issue. Now you notice that point B, exhaustion, is really a corollary of point A. That is, the petitioner or appellant must generally have exhausted all remedies made available by the state. That's true in the sense that if he does not, the state may ordinarily rely on his failure to do so as an adequate state ground for refusing to consider the federal claim that he is attempting to present to that court. The next portion of paragraph B is important, but more important in connection with criminal procedure than in this context, and so I'll discuss it there. Broadly speaking, that point is that under applicable federal decisions, the mere fact that a state decision rests on an adequate and independent state procedural ground and is therefore not reviewable by the U.S. Supreme Court under its appellate jurisdiction does not mean that the claim cannot be presented to any federal court. It can ordinarily still be presented to a federal district court on a petition for federal habeas corpus under the Supreme Court's decision in Fay versus Noya, 1963. Okay, point 6, limitations on the Supreme Court's exercise of jurisdiction. We're concerned here with the broad subject of justiciability, whether a question is presented in the manner, at the time, and by the party that renders it amenable to resolution by the traditional mechanisms of the judicial process. I've already discussed the fact that courts established pursuant to Article 3 must decide only cases or controversies. They're powerless, at least in theory, to render purely advisory opinions. Corollaries of that doctrine are discussed in the outline under item A. Moot cases, that is, cases in which the issue is no longer a live issue, cases in which resolving the issue would no longer make any difference to the rights of the parties because they're dead or because the situation is so changed that the issue has become wholly abstract, cannot be decided by federal courts. Collusive suits in which there is no real controversy between the parties cannot be decided by federal courts. Cases involving challenges to purely hypothetical legislation, legislation which has not yet been passed or which, though passed, is not threatened with actual enforcement. Such legislation is deemed premature, the controversy is said not to be ripe, and it's not the kind of case or controversy that Article 3 courts supposedly can solve. Now, those questions deal largely with questions of when certain issues can be presented to the court, because almost any issue at some appropriate time can ripen into an actual controversy. But even then, there is a second level of inquiry. Even if it's the right time to present the question, the party presenting it may be the wrong party. And the question of who is presenting the issue is the next question on the outline, the question of standing. Broadly speaking, an individual cannot assert in a federal district court the rights of anyone other than himself. There are exceptions to that doctrine, and I'll discuss those exceptions. But the general rule is that a litigant must be asserting his own concrete legal rights. And if he is simply asserting something hypothetical or asserting that some other individual may be injured or that the public generally may be injured, it's said that he doesn't have standing to present that claim. Under the Establishment Clause, for example, it would clearly be unconstitutional for the United States, or almost clearly, for the United States to send a representative to the Vatican. And yet it's fairly clear that no citizen in the United States is personally affected by such a governmental decision with enough directness for the federal courts to hold that he has standing to challenge it. That brings up the general problem of taxpayer standing. Does the fact that you are a taxpayer and a citizen entitle you to challenge a federal spending program in a federal district court? The answer, generally speaking, with an exception that I'll discuss in a moment, is no. In 1926, a woman named Mrs. Frothingham thought that Congress should not be spending money on a maternity program. Whatever her personal reasons for that view might have been, the fact is that her argument was that such a program invaded the prerogatives of the states under the 10th Amendment. Congress, she said, had exceeded its delegated authority in making such an expenditure, and she was a taxpayer and she was going to have none of it. Well, the federal court dismissed the suit. The holding in Frothingham v. Mellon was that taxpayers do not have standing in federal district courts to challenge expenditures of congressional funds, federal funds, on the general ground that they exceed the powers of the federal government. But what if a taxpayer alleges that he or she is being, in effect, compelled to contribute to an establishment of religion? Does such a taxpayer have standing to challenge an expenditure of federal funds upon a church? The answer to that kind of question was given by the Supreme Court this term in the case of Flast versus Cohen, 1968. The answer is yes. If the taxpayer can show that there is a specific constitutional limitation upon Congress's power to spend money, not just some general limitation on the allocation of powers between Congress, between the federal government and the states, but a specific protection of individual rights, which, among other things, limits the power of Congress to spend money for a given purpose, then taxpayers have a personal right to resist being forced to contribute to such a program. And even if they cannot show that their tax funds are somehow earmarked for that purpose, and even if they cannot show that their tax obligations would be somehow reduced by an invalidation of the program, they do have standing to challenge it. Now, so far, the Establishment Clause is the only one in which this kind of situation can arise. It is one of the few provisions in the Constitution which historically was designed to limit the power of the federal government to spend money, because historically one of the abuses against which the Establishment Clause was directed was the abuse of federal contributions of funds to religion. It's conceivable that there would be another area. If, for example, the U.S. Congress were to subsidize people expressing a particular political point of view, such a subsidy would obviously directly violate the First Amendment, and perhaps taxpayers generally would have standing in the federal courts to challenge it. But in the case of Flast versus Cohen, the court's ruling was very narrow, and in particular, Justices Fortas and Stewart, in separate concurring opinions, stressed that they thought the ruling applied only to the Establishment Clause. You'll notice also that under taxpayers, the outline mentions the case of United States versus Butler with respect to taxation which is earmarked for a specific purpose. You should not get the impression from the reference to Butler that whenever taxes are earmarked for a specific purpose, that any taxpayer may challenge them. For example, even if taxes were specifically earmarked for the Vietnam War, that would not mean that individuals who are taxpayers and who have no other relationship to the war except that they are citizens and taxpayers could challenge the tax as invalid in a federal court. All that Butler means is that if you as an individual are challenging your personal tax obligations, that was the case in Butler. It was a suit brought by the United States against Butler for failing to pay his taxes. If you as an individual are contesting your personal tax obligations, then of course you have standing to argue that the tax is invalid as applied to you, and you may also argue that it's invalid because of the way in which the money being taken from you is going to be spent. That's not really an exception to the general rule that citizens whose only interest in a federal program is as taxpayers may not in the federal courts challenge a federal program. Now, many state courts, including the courts of Illinois, permit state and municipal taxpayers to challenge both state and federal programs in the state courts, even though their only relationship to the programs happens to be that they are citizens and taxpayers. Note, in a great many situations, a federal constitutional claim may be presented by a municipal or a state taxpayer in a state court in a challenge to a federal statute on the ground that it's unconstitutional. The same taxpayer challenging the same statute on the same ground could not do so in a federal court, but can do so in a state court. But if the state court decides against him, he cannot obtain review in the U.S. Supreme Court. The U.S. Supreme Court is an Article III court. The requirements of standing are deemed to bind it, as well as the federal district courts, and as the case of Doremus against New Jersey in 1952, which is the leading case in this area, illustrated, the court will either dismiss the case or send the case back to the lower court with directions to dismiss it itself on the ground that standing to present a federal question is itself a federal question, and that the state court has erroneously decided that question by granting standing. There is no authoritative holding yet to the effect that state courts are powerless to give state taxpayers standing to raise federal questions in the state courts, and it would be unlikely for the Supreme Court to hold that. The important fact is that if such a suit is brought in a state court, whichever way it goes, it's not going to be reversed or decided on the merits by the U.S. Supreme Court. The general assumption, however, under all of these standing doctrines is that excluding an individual from presenting a particular question to the courts will not prevent the courts in some way from deciding that question. The assumption is there will always be someone who has standing to challenge a particular action. And when that is not true, it may be necessary for the courts to fashion some kind of an exception of necessity to the ordinary doctrine that you can assert only your own personal rights. Now, probably the most notable exception in that area was Barrows versus Jackson. In that case, there was a racially restrictive covenant, and a white seller who sold to a Negro was sued for damages by someone who said he was hurt by breach of the covenant. The state courts awarded damages, and the white seller sought review in the U.S. Supreme Court. He did not allege that his rights were in any way affected, but he argued that unless he was permitted to resist the payment of damages, that Negroes generally would be excluded from the area. There would be no way in which they could directly obtain review, since all white sellers would be deterred from selling in the first place. Agreeing with that basic proposition, the court said that the white seller should have standing to assert the rights of potential Negro buyers. Now, the example given in the outline dealing with speech is roughly of the same kind. If one is challenging a statute as an unduly vague or overbroad prohibition on freedom of speech, the mere fact that the conduct that the person making the challenge, the mere fact that the conduct he is engaged in might constitutionally be punished under a narrower or more precisely drawn piece of legislation, does not automatically mean that he cannot make an argument in the federal courts that the statute is invalid on its face because of the deterrent effect it might have on people engaging in other protected forms of speech. For example, what if a federal statute says no one shall sell or send any books through the mail? Now, anyone who wants to send a book through the mail, even if the book he wants to send is itself obscene and subject to regulation under a more narrowly drawn statute, could challenge that statute on its face. The rationale is, if the only people who could challenge it are people who are sending protected material which could not constitutionally be punished under any statute, then it's possible that no challenge would ever be made. Because if the statute is truly successful in deterring all forms of protected conduct, and that, after all, is the real vice with statutes of that kind, then there will be no one who is truly in a position to challenge it in the protected area. The only people who will be in a position to challenge it are those in the hard core of conduct that can validly be regulated. At least that's the theory of the exception in the free speech area. All right, finally, a brief word about political questions. Apart from the question of timing, when an issue may be presented to the federal courts, and the question of standing, who may present it, there are also questions of substance. There are certain kinds of issues which federal courts have traditionally declined to decide, and with very few exceptions, those categories have remained somewhat fixed. Broadly speaking, the categories are outlined under item D. The first question you should ask is the subject matter of the suit committed to a co-equal branch of the government other than the court? For example, the Constitution provides that Congress shall guarantee to the states a Republican form of government. That is, basically a democratic form of government, although the distinction is one that people are trying to make rather sharply these days. That's an issue which is thought to be reserved to Congress. There is no way in which a federal district court can decide the question whether a particular form of state government departs so broadly from the Republican form of government to which we're accustomed that it violates that clause. The thought is that it's Congress which should prevent the states from falling prey to monarchy or a truly sort of an alien form of government, that that's not the court's role. The second question you should ask is the subject one that is already a matter of declared national policy? For example, the war emergency has already been declared by the president to have been terminated. Would really wreak havoc for the courts to begin questioning, by hindsight, the wisdom of that judgment, and the courts stay away from it. Issues of that kind are thought to be too hot to handle by the judiciary. Third, are standards available for judicial resolution of issues of this kind? For example, the question of whether or not a particular amendment to the Constitution has been duly ratified is one that's difficult to decide in terms of neutral principles that courts can sort of logically apply, and so that's an issue that courts have stayed away from on the theory that it's truly a political question and one for other branches of the government. The entire area of reapportionment was thought to fall in this category before Baker versus Carr held that the question of whether a state or congressional district is properly apportioned is a justiciable question and does not present a political question beyond the cognizance of the federal courts. Finally, would enforcement of the decision be impossible? That is, even if adequate standards are available for resolving it, even if the resolution of the question is properly for the judiciary, even if it's not already a matter as to which there is a broad national consensus, the fact is that a decision by the Supreme Court might prove an embarrassing, unenforceable mandate. Probably the most obvious example would be the question of the legality of the Vietnam War. Although Justices Douglas and Stewart this term dissented from the denial of certiorari when the Supreme Court said that it would not pass upon the legality of the Vietnam War, the court's view was, as the majority expressed it, by simply denying review. Obviously, a mandate saying that the war was illegal would be a bit difficult for the court to enforce. Okay. Item B, the legislative power. Now, whenever you deal with a question on the bar involving a federal statute of any kind, the first issue that you should look for is the issue of whether that statute, quite apart from whether it infringes anyone's personal rights, whether that statute falls within Congress's delegated powers. Now, when you're dealing with a state statute, that question doesn't arise. There's no provision of the U.S. Constitution that says, in effect, that states may do only what they are authorized to do by some constitutional document. But it is true that if no specific source can be found in the United States Constitution for an action by the Congress or by the executive, that action is without authority unless it falls within one of these residual areas where the federal government has been held to have inherent power to act. And they're confined essentially to the foreign affairs sphere. But in dealing with a federal statute, your first search should be for a source of power under which Congress was authorized to enact it. Keep in mind that even if the enumerated powers of Article 1 do not specifically point to the action that Congress has taken, there's always the necessary and proper clause, which has obviously vast scope. The holding in McCulloch versus Maryland that Congress can do anything that's necessary and proper to effectuate its enumerated powers does not mean simply what it says. The necessary and proper clause does not mean simply necessary and proper. It really means expedient. If Congress thinks that something would be a good idea, and if there's any conceivable rationale whereby doing what Congress wants to do would implement something that Congress has specific power to do, then there's no question, as a matter of source of authority, that Congress has power to do it. There are some limitations on Congress's power to delegate its authority to other branches, although those limitations are not at all strictly enforced. The power, for example, to declare war is a power that Congress can't delegate. Yet it's obviously been delegated to the President, and obviously the Supreme Court is going to do nothing about it. The widest delegations can often be given in the foreign affairs area, partly because in that area the issues are so bridled with political significance that the courts would be reluctant to decide them. In the Curtis Wright decision, the leading decision in that area in 1936, the U.S. Supreme Court upheld a far broader delegation than it would have upheld in that period of history outside of the foreign affairs area. Now, turning to the specific powers enumerated in the Constitution, there are a couple of trivial ones not mentioned in the outline that will almost certainly not come up on the bar. The power to coin money and regulate its value, which is trivial not because it isn't important, but because no issues of that kind have reached the court in decades. The power to prescribe a system of patents and copyrights, again, trivial largely for the same reason. There are two other powers which are discussed elsewhere in the outline. The power to regulate elections, and we'll discuss that when we get to page 29. The powers to enforce civil rights. We'll discuss those powers when we get to page 23. But turning first to the taxing power, I want you to note at the outset that Congress can spend tax money in any way that it could rationally believe would advance the general welfare. The general welfare clause of the Constitution authorizes Congress to tax and spend for the general welfare. Now note, that clause does not provide a source of power for regulatory or any other non-spending legislation. It's a source of power only for taxing and spending tax money on anything that Congress thinks would benefit the public generally. The requirement of uniformity, as the outline points out, is not a serious restriction on Congress's tax power. It simply requires that the tax not be levied discriminatorily from one state to another on the same items. The direct tax requirement at one time, of course, posed an impediment to a practicable federal income tax, but that impediment, as you know, was removed by the 16th Amendment. We'll discuss intergovernmental immunities when we get to page 14. The limitations on the tax power that were imposed by the Butler case in terms of a tax to benefit a special group, in that case it was an agricultural processing tax, are no longer good law, although they've never been expressly overruled. There remains a kind of nebulous limitation that Congress cannot use its taxing power to regulate inherently local subjects which Congress would not otherwise have power to regulate. And that's a theory which it's worthwhile stating on the bar. If you have a federal tax that's obviously designed to regulate some aspect of state or local policy. But it's also important to point out that that doctrine probably does not have vitality today. The leading case in that area, U.S. v. Constantine, also has not been overruled, probably would not be decided the same way if it were to come up now. In the three cases listed at the bottom of item 5, Marchetti, Grosso, and one that is not listed, Haynes, Haynes, all of them versus the United States, 1968, the Supreme Court faced this broad question again. And here the court was dealing with gambling taxes and firearms taxes. These taxes were obviously designed to facilitate the prosecution of persons engaged in interstate gambling and to facilitate the prosecution of people engaged in an illicit firearms trade. Although that was their obvious purpose, they also raised some revenue, and that alone was enough as far as the Supreme Court was concerned to hold them constitutional as a matter of the federal taxing power. But one important reservation must be added here. These statutes had already come before the Supreme Court in earlier decisions, in the Carragher and Lewis decisions. At that time, the main challenge made to them was this: there is no way that one can comply with these registration requirements, registering as a gambler and then paying the appropriate tax, or registering as a dealer in firearms and paying the appropriate tax, without exposing himself to a real hazard of state or federal prosecution based upon the registration information that one discloses. The statutes didn't contain any provision that the information that one gave in registering could not be used against him in a criminal trial. On the contrary, the statutes were designed to facilitate such criminal prosecution. The material was handed over to the federal government when the individual registered and was then turned over to appropriate state prosecuting authorities. Now, if the material had been insulated from possible use in a state prosecution, the issues would have been rather different. But because they were not insulated, because complying with these registration requirements exposed individuals to possible prosecution under state and federal law, the challenge was made in the Carragher and Lewis cases that to compel compliance with these registration requirements would violate the Fifth Amendment privilege against compelled self-incrimination. Now, in those earlier decisions, Carragher and Lewis, the Supreme Court rejected that argument, largely on a rather fictional theory known as prospective incrimination. The idea was that if you file this registration statement, it's true that that may incriminate you if you choose to violate the law in the future, but of course you can always avoid violating the law, and so you're not really forced to incriminate yourself. That theory was obviously defective. It could be said in any Fifth Amendment case that someone could choose not to be a criminal. And so in the Marchetti, Grosso, and Haynes cases this term, the Supreme Court overruled those earlier decisions and held that in all of these registration areas where there is no provision in the statute which protects the individual from possible prosecution, he may resist, and if he's prosecuted for failing to register, he has a valid Fifth Amendment defense. He can argue that the reason that he did not register was that he feared that he would be prosecuted under state or federal law for doing so. That Fifth Amendment defense was upheld by the Supreme Court in these three decisions. So it's not a limitation on Congress's taxing power. Congress could still get the money. It could still do it in a way that ultimately would help to regulate commerce in the firearms and gambling areas. What it cannot do is hand over the material that it forces people to give and facilitate their prosecution with that material. So answer 58 that's given on page 27 of the outline, you might just jot that down in the margin. That answer was prepared prior to the decisions in Marchetti, Grosso, and Haynes. That answer would have to be revised in light of those decisions. Item B, the war and related powers of Congress, they're obviously extremely broad not only in terms of the direct things that Congress can do during a war, but in terms of preparatory measures that Congress can take before a war, and readjustment measures that Congress can validly pass after a war is over. In the O'Brien case, United States against O'Brien decided this term, the Supreme Court sustained for the first time the validity of peacetime conscription. The issue had never really been squarely presented. Even now, it's possible to argue that the issue wasn't really presented by the draft card burning case, the O'Brien case. But Justice Douglas, in dissenting from O'Brien, argued that it was presented and the case should be argued on that ground. In any event, it's obvious that the court would not hold peacetime conscription, peacetime selective service unconstitutional, and that, of course, is a very broad power that Congress has even before a war has been declared. After a war, all sorts of regulatory measures have been sustained. In one 1948 decision, price and rent controls were sustained as post-war measures. Military courts and tribunals can be established by Congress under its Article I power. They are subject to a certain degree of judicial review, but only in a very limited way. Federal habeas corpus is available to test the legality of anyone's detention in the United States, even detention by the military. It's critical to remember that military trials must be confined, broadly speaking, to military personnel. There have been efforts in the history of this country to declare martial law and to subject civilians to military trial, but all of those efforts so far have failed. Martial law, the Supreme Court held during the Civil War, may not be validly declared in areas where the civil government can still function effectively and where actual hostilities have not forced the civilian courts to shut down. That's the very important seminal case of Ex parte Milligan in 1866. In 1946, the court held that martial law was no longer justified in Hawaii and that court-martials there could not be sustained of civilians. The outline points out that with respect to American civilians, the court has held that Congress cannot authorize court-martial trial of such civilians, even though they may formerly have been members of the armed forces. That was a case called Toth versus Quarles. And even though they may be dependents of or employees of the armed forces overseas. The fairly well-known case of the murdering wives in Korea, Reed versus Covert in 1957. Some servicemen, wives of servicemen were charged with murder. They were put to trial by court-martial pursuant to an executive agreement. The U.S. Supreme Court held that that was unconstitutional. With respect to the curfew and exclusion of civilians from sensitive areas during wartime, the outline points out that the area of exclusion must be militarily sensitive. There must be a reasonable ground to believe that the excluded individuals would pose a risk of assistance to the enemy if they were not excluded. But all of that is purely theory. It's not really true as a matter of fact unless the case reaches the Supreme Court after the war is over, when the court feels that it can safely invalidate what Congress has done. In the infamous Korematsu decision, the Supreme Court was not in that comfortable position, and it sustained exclusion of Japanese individuals who were citizens of the United States and sustained their incarceration in what amounted to little more than concentration camps, holding that it could not review the military judgment that it was important to incarcerate them. That was an episode in our history in which it's sort of a strange episode. It's one in which people like Earl Warren and Walter Lippmann played a central role. It's somewhat illustrative of the kind of panic into which this nation can get and the fact that it cannot really rely on the Supreme Court to rescue it. With respect to the investigatory power, Congress's authority is almost plenary. It's said that, and I'm now on page 7, item C, it's said that Congress can only investigate to secure information for potential legislation. But obviously, the court is not going to hold that a given inquiry has no conceivable relationship to anything that Congress might do in a legislative sphere. And so the only real limitations upon the investigative power are negative limitations, limitations that are imposed indirectly because of the rights of witnesses who appear before a legislative tribunal. They, of course, can invoke the privilege against self-incrimination if the question asked is one that they can't answer without substantially risking incriminating themselves. But, of course, Congress can still get the information because it's always possible for the federal government to immunize anyone from the possibility of prosecution by either federal or state authorities based on any information that it may get under compulsion of any kind. It's also true that an individual can refuse to answer questions asked by a legislative committee on the ground that they are not relevant to the committee's inquiry, and the committee does have an obligation of establishing their relevance to the individual before forcing him to answer. But all of these limitations would be rather difficult to enforce. The Congress has not yet clashed with the Supreme Court in this area in the most direct way possible, which would be for Congress to simply invoke its own contempt powers to imprison an individual without resort to the judicial process. There seems to be no prohibition against that in the Constitution, and what the Supreme Court would do if confronted with it is an open question. With respect to procedural due process, again, it's not yet clear whether it's the Constitution or just practice that requires a large number of procedural rights to be accorded to witnesses before appropriate investigating bodies. I don't have anything to add to that section of the outline which is labeled D, property power. It's not something which is at all likely to come up on the bar, and nor is the bankruptcy power on page 8, item E. There I simply want to make one comment about subpoint 3. You note it says there the bankruptcy power is also subject to the due process limitation of the Fifth Amendment. Now the Fifth Amendment provides that the federal government cannot take life, liberty, or property without due process of law. And of course that's a limitation on the bankruptcy power. It's a limitation on any power exercised by the federal government. The postal power, item F, is extremely broad. Congress can regulate the entire postal service in any reasonable way, and any reasonable way is usually just a phrase that the courts use to avoid creating the impression that they've abdicated authority. Any reasonable way means any way at all. There is, however, an important limitation on this congressional power, as there is, again, on any exercise of congressional power, and that is that it must not be exercised in such a way as to deprive particular individuals of rights secured by the Bill of Rights. Most importantly in this area are rights secured by the First Amendment. Only 2 actions of Congress have ever been held unconstitutional by the U.S. Supreme Court on the ground that they violated the First Amendment. One of them was in this postal area, Lamont versus the Postmaster General of the United States. In that case, Corliss Lamont objected to a provision whereby he was forced, as was anyone else who wanted to receive mail from certain communist action organizations, to submit his name to the post office as someone who was interested in such mail. Now obviously that could exercise an important deterrent effect on people who wanted to read whatever they wanted to read. And stressing the fact that the First Amendment is designed to protect listeners and readers at least as much as to protect speakers, the U.S. Supreme Court held that requirement unconstitutional in Lamont versus Postmaster General just several years ago, and it was, surprisingly enough, the first time that the First Amendment was ever invoked to hold invalid an act of Congress. It had been invoked plenty of times to invalidate state laws, which is a little ironic since the First Amendment says Congress shall pass no law abridging the freedom of the speech. But as you know, provisions of that kind have been incorporated through the Due Process Clause of the 14th Amendment. They've been held to be limitations on state as well as federal power. I'll discuss that in greater detail later on. But right now the point I want to make is that the First Amendment was applied to the states long before it was applied to its direct subject, namely Congress. And it was never applied to Congress before the Lamont decision. It was applied again to invalidate a congressional law this term in United States versus Robel, 1968. A very important decision that I'll discuss a little later on. Okay, with respect to the power over citizenship, broadly speaking, Congress's power is almost limitless with respect to excluding aliens who've never set foot in this country. Once they are here, they are persons for purposes of the due process clauses of the 5th and 14th Amendment, and may not be deprived of life, liberty, or property by either the state or federal governments without due process of law. But even after an alien has been here for a number of years, a number of things may be done to him that perhaps cannot be done to a citizen. For example, in Heresiades in 1952, the Supreme Court upheld the deportation of a man who had resided as an alien in the United States for over 30 years on the ground that he was a communist. But his party membership, his membership in the Communist Party, had terminated a great many years before the statute was enacted which said that communists should be deported. Now, the argument was made that that was therefore an invalid ex post facto law. The Supreme Court rejected the argument, saying that deportation is not punishment, therefore it's not an invalid ex post facto law. So the power over aliens, even those who've been here for a long time, is still fairly broad. Congress can, of course, impose any reasonable regulations upon aliens while they're in this country, registration laws, laws designed to keep track of where they are and who they are. What it cannot do is first make them naturalized citizens and then take away their citizenship involuntarily. The U.S. Supreme Court held in the case on the outline in item 2 at the top of page 9, in the case of Ephraim versus Rusk, that Congress may not involuntarily expatriate a citizen, that is, take away his citizenship, for voting in a foreign political election, or, the court held, for any reason whatever. The only question that was left open, and the question that might arise on the bar if this issue comes up, is the question of what kinds of acts or statements by a naturalized or other citizen might validly be deemed to constitute voluntary relinquishment of citizenship by a kind of presumption. That question was left open. So if Congress were to pass a law saying that from now on, anyone who votes in a foreign political election shall be deemed voluntarily to have relinquished his citizenship, obviously that would be struck down as just an attempt to get around this decision of Freund v. Rust. But if Congress passes a law that says anyone who says, I hate this country and don't want to live here anymore, shall be deemed to have voluntarily relinquished his citizenship, that might pose a closer question. With respect to item H, the admiralty power, note that it's exclusive, and note, too, that it's extremely broad. It applies not only to large bodies of water or to the oceans, it applies to the smallest conceivable tributaries. If you can float a matchstick on a body of water, it's probably going to be deemed navigable for purposes of the federal admiralty power. It was once said of Justice Story that if someone came into his courtroom with a bucket with a corn cob floating in it, he would at once extend the admiralty jurisdiction of the United States over that body of water. Next, item I, the commerce power. This is perhaps the broadest source of congressional authority today. It has virtually no affirmative limitations. There's almost nothing that Congress can do now that couldn't arguably be sustained as an exercise of the commerce power. In the past 20 years, not one federal statute has been held to exceed Congress's power to regulate interstate commerce. There are, however, some specific limitations in the Constitution. You'll notice item 1, no preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, so that however powerful California or New York should become in the Congress, one kind of log rolling that is prohibited by the Constitution is the kind that would provide such a preference. It's also important to note that however broad Congress's power in the commerce area is, it is shared with the states, and that will pose probably one of the most difficult areas that we'll discuss later on, the way in which you decide whether an attempt by the states to regulate interstate commerce violates the implied limitations of the Commerce Clause upon such state regulation. The broadest possible definition of commerce was really given fairly early by Chief Justice Marshall in Gibbons versus Ogden. He referred to it as every species of commercial intercourse which concerns more states than one. Now, at one point in the history of American constitutional law, it was important to identify whether some particular item that was being regulated by the Congress was or was not commerce. It was a kind of metaphysical inquiry. Is manufacturing commerce? No, it isn't. Is transportation commerce? Yes, it is. Well, no longer does the court look for this kind of a black or white test. It's no longer critical to ask whether something is interstate commerce. The only question is, can it be regulated under the commerce power? Now, turn to item 5 on page 10. That's the present doctrine. Something can be regulated under the commerce power no matter what it is, if it has any substantial effect upon interstate commerce. Right now, the federal commerce power then embraces any phrase of the economy which, taken either separately or cumulatively, may affect the flow of business or other activity between two or more states. And that's true even though the regulation itself is not directed at what appears to be an economic or business evil. In Katzenbach against McClung, for example, and in Heart of Atlanta Motel versus United States, both under example 2 in item 5 on page 10 of your outline. The Supreme Court sustained provisions of the Civil Rights Act of 1964 on the ground that Congress does have power to regulate restaurants which purchase food that travels in interstate commerce, or motels, some of whose travelers travel in interstate commerce. Broadly speaking, Congress can protect even the local activities of an institution which is engaged in some other respect in interstate commerce. In answering questions in this area, you might note first that the commerce power was originally rather narrowly defined, was originally defined in very sweeping general terms by the Supreme Court. Then during the 1920s and 30s it was narrowed. Now it's virtually plenary and there are almost no affirmative limitations upon it. With respect to item C, the executive power, you'll note that though the executive power is vested by the Constitution in the President, it can of course be delegated, and as I've mentioned earlier, very broad delegations accompanied by almost no standards as to how the power is to be exercised, have been sustained in the foreign policy area. But if on the bar you do have a question in which the President has delegated to someone else the power to make decisions with virtually no guidelines and no standards, it's important to note that there is at least a possible question whether that delegation violates the U.S. Constitution because it gives to someone else power that the U.S. Constitution vests in the President. But after noting that, you should note that nothing has been held invalid by the Supreme Court, nothing of importance has been held invalid by the Supreme Court on delegation grounds for a long time, and it's unlikely that it would be. With respect to the removal of officers, there are two categories. I'm on page 11, item A. The President may remove at will, without stating any reasons, without conducting a hearing, any purely executive officer, and this would certainly include, for example, members of his cabinet. What he may not do is summarily remove, except by the procedures established by Congress, commissioners of independent administrative agencies like the FCC or the FTC. The question in each case is one of statutory interpretation. Did the statute which created the agency or the commission intend to permit the President to exercise broad dismissal power? In 1958, for example, the question was whether President Eisenhower was acting constitutionally in dismissing a member of the War Claims Commission. The statutes, as usual, didn't specify whether the President could or could not make such dismissals. For political reasons, that's often not mentioned in a statute. But the question before the court was, did the legislative history show such an intent to insulate the War Claims Commission from executive influence that it would be incompatible with that purpose to permit the executive to simply fire anyone he wanted? And the conclusion to that question was yes, and the court held that the President had exceeded his powers by dismissing the member of the War Claims Commission. Congress apparently has no power summarily to remove someone by itself without the President. It's at least clear, as the outline points out, that if it removes a presidential appointee or tries to do so with punitive intent in order to inflict some kind of punishment, that is invalid as a bill of attainder. And that was essentially the holding of United States versus Lovett. Moreover, under a more recent holding, United States versus Brown, 1965, whether or not a measure is intended to inflict punishment is apparently irrelevant to deciding whether it should be deemed a bill of attainder. In United States against Brown, former members of the Communist Party were disqualified from serving as labor union officials. The Supreme Court said that although it didn't name particular individuals, this law identified a small, specific group of people, inflicted upon all of them punishment without judicial trial. That, the court said, was a bill of attainder, and it didn't matter that Congress's purpose was to protect labor unions rather than to punish these individuals. Punitive intent, the court said, was irrelevant. The pardoning power and the veto power is not at all important for purposes of the bar. The President, it said, has no legislative power in internal affairs. Of course, technically speaking, he has no legislative power at all, but his power to conduct foreign affairs and to formulate foreign policy is so broad that it might as well be legislative power. But in internal affairs, his powers are far more limited. The leading decision in this area, an extremely important one, is Youngstown Sheet and Tube v. Sawyer. It's listed here at the bottom of item 2. That's the steel seizure case of 1951. It was a 6-3 decision by the Supreme Court. It was based on a holding that because Congress in the Taft-Hartley law did not specifically authorize the President to seize the steel mills or to seize any industry in a period of national emergency, that Congress intended to withhold that power from the President, that its silence was interpreted as a prohibition. But at least 5 of the justices in that case, including 2 of the 6 who were in the majority, indicated their view that the President may have some inherent powers, even in internal affairs, to take essentially lawmaking steps, if necessary, in a period of national emergency, so that it would be an oversimplification to describe the steel seizure case as holding that the President simply has no lawmaking powers domestically in times of national emergency. It really suggests simply that the court will examine such an exercise of power very closely, and it may even interpret congressional silence in the area as a prohibition, which will be binding upon the President because the power exercised is in the legislative rather than the executive realm. The President's powers during actual hostilities, the top of page 12, are extremely broad even without a congressional declaration of war. Those powers include the power to establish military tribunals, but I've pointed out that the power to subject civilians to trial by those tribunals has been severely circumscribed by the U.S. Supreme Court. I've already indicated the breadth of the President's powers in the foreign relations area and the fact that in that area the President can delegate a great deal of authority with very few guidelines that he might not validly be able to delegate elsewhere. With respect now to the treaty power granted to the President by and with the advice and consent of the Senate, providing 2/3 of the senators present concur. Regarding the treaty power, the critical point is that treaties are on an equivalent supremacy status with federal statutes. If a treaty and a state law conflict, the treaty prevails. If a treaty and a federal statute, an act of Congress, conflict, the most recent of the two prevails. Now, what about a treaty that conflicts directly with the U.S. Constitution? Well, there are two such kinds of potential conflicts, as I think might have been indicated by the discussion that I began with in terms of looking for a source of power. A treaty might conflict with an act of Congress, with the Constitution. Well, let me give you a break now and I'll resume here. I'd like you to be back in 10 minutes, and if you're not, I'll either have to begin right away or go over, because there's an awful lot to cover today, so I'd appreciate it if you could make it in 10 minutes. The supremacy status of treaties. A great many treaties, though they are theoretically supreme, don't have any operative effect because they're not self-executing. They're rather broad declarations which simply authorize Congress or the national legislature of a given country to do something. The United Nations Charter is probably of that kind. The United States Supreme Court has never had occasion to construe it in this context, but some of the state courts, in particular the Supreme Court of California, though not that of Illinois, confronted the question and have held that those provisions of the UN Charter, which require equal treatment on grounds of race and religion, do not bind individuals or states within the United States. They only authorize Congress to implement those provisions with legislation if Congress chooses to do so. That treaty, and many others like it, is therefore supreme only in a theoretical sense. It's not self-executing and therefore does not have operative effect. Now, I've already mentioned that when there's a conflict between a treaty and a statute, the last in time prevails. Two kinds of conflicts may arise involving treaties and the U.S. Constitution. The first deals with sources of power. Now, a federal statute which may be held unconstitutional prior to the adoption of a treaty may be held constitutional afterwards if that statute is necessary and proper to implement the treaty. In Missouri versus Holland, which is really the only case in this area, 1920, the Migratory Bird Act, which had previously been declared unconstitutional under a fairly restrictive view of the commerce power, that act would probably now be sustained under the commerce power, was later held valid by the Supreme Court when it was enacted to implement a treaty between the United States and Canada. So federal legislation which might be invalid in the absence of a treaty because it doesn't fall within any of the enumerated powers and is not necessary or proper to the implementation of any enumerated power, might nonetheless be valid to implement a treaty. At the same time, as the outline points out, a treaty cannot confer on Congress powers it would not otherwise possess, in the sense that it cannot authorize Congress to violate specific provisions of the Constitution. I mentioned the case earlier of the murdering wives, the Reed versus Covert case, 1957, in which the Supreme Court held that an executive agreement between the President and another nation could not authorize the President to subject civilians abroad to court-martial in violation of rights that were secured by the Bill of Rights. The court also said in dictum that a treaty could not authorize Congress and or the President, acting singly or together, to violate any of the provisions of the Bill of Rights. But that was only dictum. The U.S. Supreme Court has never, I repeat, never, held a treaty to be unconstitutional or held action pursuant to a treaty to be unconstitutional because the treaty authorized Congress to violate the Constitution. There are theoretical limitations on the treaty power. There are dicta in some Supreme Court decisions to the effect that treaties can only deal with matters in the foreign relations realm, and that a treaty which attempted to alter the whole domestic structure of government, for example, might be invalid, but these are just rather offhand comments by the court, and they have not been really raised by any question presented to the court. I've discussed briefly executive agreements, the one involved in Reed versus Covert. This is the top of page 13. Such agreements do not find their source in any specific clause of the Constitution, but they are accepted practice, and it is now established that such treaties are, such agreements, executive agreements, though they are not ratified by the Senate, they're not subject to Senate ratification, are nonetheless supreme over conflicting state legislation. The Supreme Court held in United States against Pink, 1942, that if there's any conflict between a state law and an agreement made between the President of the United States and a foreign government, that agreement prevails and the state law falls. However, you'll notice in the outline that there's some indication in some Supreme Court decisions that executive agreements may even be regarded as co-equal with treaties and valid acts of Congress. In other words, if there's a valid act of Congress or a treaty and a subsequent executive agreement conflicts with it, under the principle that the last in time prevails, there are some dicta to the effect that the executive agreement would prevail and would override the prior statute or treaty. I think, despite these dicta, it's very unlikely, after the Steele seizure case of 1951, that the Supreme Court would actually make such a holding. Because if the President does not have power to override even an implied prohibition by Congress domestically, it's unlikely that in the realm of foreign affairs, the President could override by executive agreement a previous valid act of Congress or a previous valid treaty which had been ratified by the Senate. With respect broadly to the federal system, you'll notice the first category deals with relative spheres of national and state power. In a great many bar exam questions, you're going to be faced with the general problem of whether a given action by the state or federal government infringes the sovereignty somehow of the other. There are certain areas where the powers of the states, as the outline points out, are expressly limited by the Constitution. The Constitution prohibits the states from entering into treaties with other countries, prohibits them from coining money, from levying duties on exports or imports. There's also a broad residue of things that the states cannot do, not because of any explicit prohibition in the Constitution, but rather because of the nature of the power involved. In the entire foreign affairs area, it's thought that it's critical for the nation to speak with one voice. That it's hard enough to deal with Charles de Gaulle without all of the states running interference. And so the basic doctrine is that states can't meddle in foreign affairs, and any action by the states which is deemed to be an intrusion in the foreign affairs realm is held to be a transgression of an inherently federal power. The most recent and important decision in this area, in 1968, is Schernig, Z-S-C-H-E-R-N-I-G versus Miller. In that case, Oregon had passed a law which provided that if someone dies in Oregon and leaves his property to someone in a foreign country, that the property cannot be sent to the heir in the foreign country unless the foreign country meets three requirements. First of all, its domestic laws must not discriminate against Americans in its inheritance laws. Secondly, its laws must permit the rapid remittance of proceeds to the United States from any estate that's probated abroad. And thirdly, the nation's laws must not be confiscatory. That is, there must be some guarantee that when the inheritance reaches the foreign country, it won't be confiscated, but its benefit will really go to the intended heir. Now, some Oregon decedents left property to some heirs in East Germany. The heirs were not entitled under the Oregon statute to receive the money, and they challenged the validity of the Oregon statute. The challenge was upheld in the U.S. Supreme Court. The court held that here state X, is sufficient to support jurisdiction to tax? Is there a tax situs in state X? As to the Commerce Clause issue, the question is whether the particular tax imposes an undue burden on interstate commerce or discriminates against interstate transactions, because any tax which does that is invalid under the Commerce Clause. Now, although Pacific Airlines is an out-of-state corporation, a Texas corporation, with planes based in Houston, those planes made regular stops in X, and the airline derived a significant part of its revenue from its flights from X to Seattle. Having provided airport facilities and business opportunities to Pacific Airlines, X has certainly contributed the requisite protection and benefit to the airline to assert the right to tax the aircraft. Now, even if the same planes do not regularly land in X, a property tax can be imposed upon the planes because their presence there is not wholly fortuitous or sporadic. It's related to an ongoing business. The state does provide meaningful protection. But the Due Process Clause, as well as the Commerce Clause, does require that the tax be fairly apportioned. Now, in this case, and the question is unusual in that respect, the bar examiners have told you that it's fairly apportioned, that part is conceded. Now, once it's established that a taxpayer's contact with a state suffices for due process purposes to justify the imposition of a property tax, there's no undue burden on interstate commerce as long as the tax is fairly apportioned. That's really the only question that has to be asked at that point. That's been stipulated. But if there had been no such stipulation, and a more common bar exam question would not tell you anything about how the tax had been apportioned, would require you to know that that was an issue. In fact, it would probably mention nothing about the apportionment formula that was used, then you would have had to discuss that issue. To be valid, the apportionment formula would have to reflect, at least roughly, the average physical presence of the taxpayer's planes in X during the tax year. Now, the answer that's given at the end of the outline, for those of you who've looked at it, at page 21, suggests that there's some problem with permitting state X to impose any tax in this case, because in the Northwest Airlines case in 1944, the Supreme Court held that the domicile state of an airline may tax the full value of the airline's entire fleet, although all of the planes were continuously in interstate commerce. So if the domicile state can tax everything, in this case Texas, and each of the individual states can tax a fairly apportioned amount, doesn't that amount to multiple taxation and an undue burden on commerce? The answer is that the domicile tax cannot necessarily tax everything. In the Northwest Airlines case, Northwest Airlines had not established that it was actually subjected to multiple taxation in other states. But when that is established, the court comes out differently. In the Standard Oil Company versus Peck, in 1952, for example, the Supreme Court held that an Ohio tax on oil barges owned by an Ohio corporation but used both in and out of Ohio, which had a regular tax situs in other states so that they were taxed by other states as well, could not be subject to an unapportioned ad valorem property tax by the domicile state, in that case Ohio. So that here, because a tax situs is established in another state, and because that other state is actually imposing taxation, the airline would have no real difficulty establishing, if it were to be subjected to a full tax by the state of Texas, establishing that that was invalid under the Standard Oil decision. Partly for that reason, because such protection was available, the Supreme Court in Braniff versus Nebraska Board held in 1954 that a tax of the kind described in this question is valid. Okay, next I want to talk about gross receipts and net income taxes on an interstate enterprise. The outline just says gross receipts, but the same principles, basically speaking, apply to both. These taxes are sustained if they are not discriminatory against interstate commerce and if they're fairly apportioned. Only here, apportionment must be in terms not of physical presence, but in terms of intrastate business or intrastate income or intrastate transactions. The state must make a reasonable effort to decide what percentage of the business is generated in that state or is somehow attributable to that state. It can tax gross receipts or net income only to the extent of that percentage. But one important note, a lack of apportionment of a gross receipts tax may not be fatal in some circumstances. If the tax itself is small in absolute terms, if the local activities of the interstate business are substantial, and if no unfair burden is actually demonstrated due to actual multiple taxation in other states. In those circumstances, an unapportioned gross receipts tax of a fixed percentage of the total gross receipts of the enterprise may be sustained. The Supreme Court sustained such tax in General Motors versus Washington in 1964, and though some people who are cynics about the court's operation might say that that was simply because the court didn't like General Motors, if one wants to derive any neutral principles from that decision, they are the ones that I've described. Note also that an in lieu gross receipts tax, that is a gross receipts tax in lieu of all other taxes otherwise owable to the state, has been sustained by the court. I want to talk next about sales taxes. Now here, as in the case of property taxes upon commodities as opposed to instrumentalities, there is no apportionment problem. There's only one sale, and the state may or may not tax the proceeds of that sale or the net income from that sale. The question is, which state can tax a sale, or in some cases, can any state tax it? Broadly speaking, the state which provides some benefit in connection with a transaction is the one that can tax. The state in which delivery takes place is ordinarily the one that can validly collect a tax from the seller on the theory that it's providing protection. Delivery is in that case viewed as the incident that the state may permissibly tax. But note that if it's a purely mail order transaction, and if the delivery is not attributable to some further local benefit in the state that seeks to tax, then the sales tax may not be imposed simply because the state that seeks to impose it is the state where delivery happened to occur. Let's take an example. The seller's state is S, the buyer's state is B. There's a mail order sale from S to B. Nothing beyond that. No local solicitation in B, no office in B on the part of the seller. In such a case, B cannot impose a sales tax on the transaction. S can impose such a tax unless the sale was generated by a local outlet of the seller in the buyer's state, B. If it was so generated, then B can probably impose a sales tax, but S cannot. Now, the situation is different with respect to use taxes. No matter where a product comes from, the state that it ends up in may validly impose a tax on the privilege of using the object or the item or the property within the state that imposes the use tax. One important point, however, should be made about use taxes, and that is that if the use tax is so structured that it encourages people to purchase products locally rather than in other states, it may be held invalid. There was one Louisiana use tax which used a very strange tax base, and if you thought about it for a while, you could see that anyone subjected to that use tax would be at a substantial disadvantage if he purchased products from neighboring states. And the Supreme Court held that use tax invalid in Henneford versus Silas Mason Company, 1937. That's the case at the bottom of page 20. That was also the case that contained a dictum which said that a use tax may be valid even though no credit is allowed for a sales tax that's already been paid for the sale of the item on which the use tax is imposed. Now, although the fact that a product comes from another state does not prevent the state where it ends up from imposing a use tax on the privilege of using it, the fact that the product comes from another state may be an effective bar to the collection of that use tax. For practical purposes, it's almost impossible for a state to collect a use tax from the person who's actually using the product. Ordinarily, the use tax, like the sales tax, must be reflected in the price of the product, and it's the seller that's counted on to collect the tax from the buyer and the ultimate user, and to pay the tax, whether it's a sales tax or a use tax, to the state. Now, if a sale is made in State A and the product ends up in State B, to what extent can State B compel the seller in State A to collect the use tax and to remit the proceeds to State B? Well, just as there is a due process of law problem whenever a state seeks to impose a property tax on property outside the state, so there is a similar problem whenever it seeks to extend its jurisdiction, as it were, to a seller in another state and force him to collect a use tax and pay it to the state. The basic line that the court has drawn in this area has not been terribly responsive to economic reality. In the most important category of cases, the case of mail order sales from one state to another. The test that the court has applied has not been how widely is the market in which the sale is ultimately made exploited by the seller. How much business does the seller do there? How much money does he earn there? How much does he advertise there? If those were the criteria, there would have been no doubt in the case of National Bellis Hess against the Department of Revenue that the state of Illinois could validly compel a Missouri mail order house to collect use taxes because it did about $2 million of business in this state. It had extensive advertising and so on. But the business was completely mail order. It had no agents in the state of Illinois, and that has been the determining factor. If the mail order business does have employees or independent contractors in the state who help it make the sales, then the state where these contractors or employees are located may impose a use tax and may compel the out-of-state seller, the mail order house, to collect that use tax and remit the proceeds to the taxing state. In Scripto versus, well, I forgot the other party. It was the Scripto case in 1960. The Supreme Court held, doesn't matter. The Supreme Court held that a mail order house with independent contractors in the taxing state could be taxed. In National Bellis Hess, there were no local agents. The tax was held invalid. The use tax could not be collected. It doesn't mean that the person who ultimately uses what he purchases through the mail order sale cannot be taxed by the state. If the state wants to adopt a cumbersome system of collections from everybody who happens to buy a pencil in the using state, it was pencils that were involved in the Scripto case. But the state has no effective way of collecting it. The court was afraid. The court said two things. It said this violates the Due Process Clause and it violates the Commerce Clause. It violates the Commerce Clause because of the multiple burdens that could occur. If every state in which a mail order house does business could force it to collect use taxes and remit them to the state in which the product ultimately ends up, that would be, the court thought, crippling. All right. With respect to privilege, franchise, license, and occupation taxes, this is an area where the court has been perhaps more formalistic and more metaphysical than any other. The search is always for that magic thing, the incidence of the tax. If the tax is directly a tax upon the privilege of soliciting interstate business, it's deemed invalid. But if it's a tax on some local activity, like a tax, for example, on the privilege of operating a business inside the state, then it's not automatically deemed invalid. Another mechanical line the court has drawn in this area, if the tax, the privilege tax, the license tax, operates as a condition precedent to the privilege of doing business in the state, either because someone who does business without getting that license is subject to criminal punishment or because he's subject to ouster through some administrative process, then the court tends almost unthinkingly to hold the tax invalid. In all of these areas, the supposed inquiry is whether the tax is reasonably related to benefits and protection provided by the state and whether it's an undue burden on interstate commerce. But in answering both of those questions, the court tends often to look to the label of the tax rather than to its substance or to its effect. And the best example of that, I think, is the one given in item 5B. Two cases, both Railway Express Agency versus Virginia. Both involved a tax with exactly the same effect. They came out in opposite ways. A fairly apportioned tax was relabeled by the state of Virginia. Originally, it had been called a license tax for the privilege of doing business in Virginia. Court said that's no good. Interstate business doesn't need to pay anything for the privilege of engaging in interstate business. Then they had the same tax, same amount on the same people, but called it a franchise tax in lieu of all other taxes on rolling stock, cash, or intangibles in Virginia. Supreme Court said, well, there's no demonstration that that's unreasonable. There's no demonstration that if we actually computed it out, that a fairly apportioned ad valorem property tax coupled with all these other taxes wouldn't have yielded the same result. This isn't a tax on the privilege of doing interstate business. It's valid. So in answering questions in this area, watch out for the labels, and watch out, too, for bar exam questions which don't provide the labels. Very often in this area, the bar examiners, and they're the ones who are responsible for the questions at the back of this outline, will not give you the facts that you need to meaningfully answer the question. And so you'll have to answer it in various on alternative hypotheses. You'll have to say that in this area the court has been formalistic. The result may well turn on the precise phraseology of the state statute, which we don't have. If it's denominated a tax on the privilege of engaging in interstate commerce, it may be held invalid. but the same tax under a different label may be sustained. Now, there are two lines of cases which again illustrate a kind of unrealistic formalism in this area, but they're not terribly hard for you to distinguish for bar purposes. They are the drummer cases, item C, and the peddler cases, item D. Now, the court has drawn a fairly fine line between the activity of taking orders for future delivery from a stock of goods outside the state, or taking orders for future fulfillment by performing services outside the state, on the one hand, and on the other hand, delivering goods or providing services from a local stock that's carried around within the state. In the former case, when orders are solicited for future delivery, the court has presumed that the impact would be to unduly burden interstate commerce. The idea is pretty simple. I mean, the idea is that if you charge somebody, for example, a flat fee of $500 for the privilege of entering a local market and soliciting business there, he will be deterred from doing that unless he expects to do enough business there so that it's profitable and so that he can offset that $500. That operates as a kind of exclusion of any business from outside that locality. Any business that will be operating only sporadically and that will be subject to such burdens in every city, for example, in which it operates, is going to steer clear of that kind of operation. So the court has assumed that that's bad, and in general the court has held that any tax, however measured, especially if it's measured by a large fixed fee, however, upon the privilege of soliciting orders for future delivery is invalid. On the other hand, when you're dealing with someone who's operating from a local stock of goods, he's usually competing with other people who operate in the same way, in effect with other peddlers. As long as they're all subject to the same non-discriminatory tax, the court assumes that it does not have an exclusionary effect and comes out the other way. So that you can be, if you're delivering soft drinks from a truck that's going from house to house, even though you come from another state, you may be subjected to a non-discriminatory tax on the privilege of making such deliveries. But if you're going from house to house taking orders for future delivery of magazines or something from another state, even if the impact of the tax is not really discriminatory, you do not have to pay it, you're immune. Probably the real reason for this distinction is wholly historical. The first peddler case arose in the context of a criminal prosecution. The first drummer case arose in the context of a criminal prosecution of a drummer. The court was somewhat sympathetic and it appeared more exclusionary, so it came out in favor of the drummer and said that the state had the burden of showing non-discrimination. In the first peddler case, it wasn't a criminal prosecution at all. It was an attempt by the peddler to recover the amount he had paid for the tax. That didn't seem nearly as sympathetic. The case came out the other way. As often happens in the law, including constitutional law, doctrinal distinctions start from historical accidents. I want to add one point on page 22. A state can validly impose a tax on the privilege of using the state highways as long as no discrimination is shown against interstate trucking, and as long as there's no proof that the amount of tax the state imposes is unreasonable in light of the benefits received by the highway user. The court talks in terms of interstate commerce paying its own way, and it's really the burden of interstate commerce in cases like this to show that the state is requiring it to do much more than pay its own way, but it's placing an undue burden on interstate commerce. Okay, with respect to Roman numeral 4, individual guarantees against governmental or private action, the Constitution, by and large, contains no limitations on what private parties may do. There are a couple of exceptions. The court has held that the right to travel is inherent in the entire structure of the Constitution and is protected from private as well as governmental interference. The 13th Amendment, which abolishes slavery, applies as well to private efforts to subject someone to involuntary servitude as it does to governmental action. By and large, however, only the government is subject to constitutional restraints. And in any constitutional law question, you've got at the outset to identify how it is that the government and not some private individual is violating the Constitution. Also, with few exceptions, the restrictions in the Constitution are restrictions upon action by the federal government. There are very few restraints spelled out in the Constitution on what the states can do. There are limitations on imports and exports. The states are prohibited from passing ex post facto laws and bills of attainder. And under the 14th Amendment, the states may not deprive any person of life, liberty, or property without due process of law and may not deprive him of the equal protection of the laws. But outside of these restrictions, there are a few important ones. Nonetheless, the court has held that the Due Process Clause of the 14th Amendment incorporates a great many of the rights that are protected by the Bill of Rights against federal action. The right to be free of unreasonable restraints on speech and religion. These are rights that apply to the states as well as the federal government. The criminal procedure outline contains a fairly exhaustive list of those provisions in the Bill of Rights which have thus been selectively incorporated and have been included in that liberty which the states cannot deprive people of under the 14th Amendment. And although I'm not going to go over that list in any detail either now or when I discuss criminal procedure with you tomorrow, I recommend that you familiarize yourself with those specific guarantees. The whole process has been one of selective incorporation. The court has not held that the Bill of Rights as a body is applicable to the states because of the Due Process Clause. But it has held that in deciding whether or not a particular right is sufficiently fundamental to be deemed part of that liberty which the states may not unduly infringe under the 14th Amendment, in deciding whether something is fundamental enough, the first place that you look is to the Bill of Rights. If the right is secured against federal interference by the Bill of Rights, it is probable that it will be deemed sufficiently fundamental to be protected by the 14th Amendment against state infringement. Now, with respect to the 13th Amendment, there's been a very important recent case that you're probably aware of, Jones v. Alfred Mayer, 1968. There, I simply want to mention that the court held that the 13th Amendment abolishes slavery and also empowers Congress to abolish anything that might be deemed an incident or a relic of slavery, including private racial discrimination in the sale or rental of real or personal property. The court also held that the Civil Rights Act of 1866 did just that it forbade all private and public discrimination in all property transactions in the United States. Congress does have the power, as a result of Jones v. Alfred Mayer and as a result of certain other decisions, to restrict private action in a number of areas, even where the Constitution itself speaks only about governmental or state action. Congress may prohibit private action which interferes with free commerce among the several states. And under the 1964 Civil Rights Act, which the court sustained as an exercise of the commerce power, Congress prohibited all kinds of private as well as public action. Congress, in regulating elections, under Article 1, Section 4 of the Constitution, which gives Congress the power to regulate congressional elections, may prohibit private interference with those elections. Even in dealing with state elections, under the 15th Amendment, the Supreme Court has held that although the 15th Amendment itself provides only that the states may not deprive persons of the right to vote on grounds of race or religion or previous condition of servitude, nonetheless, Congress can go further than that, and in order to implement that amendment, Congress can prohibit action by private individuals. It can also prohibit action which may not be strictly deemed a denial of the right to vote. There's a gray area in which Congress can prohibit something that the court itself would not be willing to say violates the Constitution. It can do so to implement the Constitution whenever it has power by necessary or appropriate legislation to do so. And 6 members of the court in Guest versus the United States said in 2 different dicta, though there was no opinion of the court saying this, that Congress has the power to enforce the 14th Amendment by banning private action which interferes with rights that the 14th Amendment itself secures against state action. Now, the right in question must still be defined in terms of some public involvement. The right to vote in a public election, the right to go to public school, to use public facilities. But once the right itself is in this kind of public sector, then, according to the views of at least 6 members of the court, Congress has the power under the 14th Amendment to prohibit private interference with those rights, although the 14th Amendment itself prohibits only state interference. Now, what about the whole problem of state interference and state action? It's very difficult to summarize this area adequately, partly because so many of the decisions in this area and so much of the writing starts out from a rather misleading premise, as though the search is for some mystical thing that one calls state action. In almost every case in this area, there could be no conceivable doubt that the state has acted. There's always a state agency involved, or a court or a legislature, that has acted. The question is, Has the state violated the Constitution? Has the state acted in a discriminatory way? For example, let's suppose somebody doesn't want Negroes on his private property, and they decide to camp there overnight. He invokes the trespass laws. He says, please leave. They don't leave. He asks the police to eject them. The police come and they do so. They're prosecuted for violating the trespass laws. There's been plenty of state action. The police have been involved. The courts have been involved. But on the facts that I've so far described, there's been no state discrimination. The discrimination, if any, has been purely private. And when the state simply provides neutral facilities for the effectuation of somebody's private will, the fact that he personally is acting out of a discriminatory motive does not mean that the state is sufficiently involved with that discrimination to be violating the Equal Protection Clause of the 14th Amendment. The state is not depriving anyone of the equal protection of the laws. On the contrary, it might be argued that if it refused to help me because I'm a bigot, it might be depriving me of the equal protection of the laws. Okay, so that's the first problem with state action. You've got to find more than just action by the state. You've got to find involvement by the state with the discrimination itself. Now, that involvement might be found in a number of ways, some of them rather indirect. Look at item 2, for example, municipal regulations. This is a reference to the 63 and 64 sit-in decisions. One of those decisions, Lombard against Louisiana, provides a rather good illustration. There was no statute or ordinance that required segregation. But the mayor and the chief of police had announced publicly that they would invoke the trespass and breach of the peace laws to enforce a local custom of racial separation in eating places. Now, someone in a restaurant who didn't want Negroes there said, I want them to leave. And in accord with the promise that had been made, the trespass laws were invoked. Now, if there had not been that promise in advance, the case might resemble the kind of case I've just described, in which a discriminatory private decision is simply enforced by neutral state action, no violation of the Equal Protection Clause. But here, because the state had itself taken a position, because the state was doing the discriminating or encouraging the discriminating, the Supreme Court held that the state had deprived the people who were convicted of trespass and convicted of engaging in the sit-in, it had deprived them of the equal protection of the laws. So it's critical to distinguish between state involvement in the discrimination and simply state action. In that case, by the way, there was no real proof that the individual's decision to invoke the trespass laws was motivated by the prior announcement of state policy. But the absence of such proof is not fatal. The critical thing is whether symbolically the state has put itself on the side of discrimination. That's one way of explaining the Supreme Court's decision in Reitman against Mulkey, Proposition 14, Item 6, from the bottom of page 23 to 3 to the top of page 24. There, the California Constitution had been amended so that in the future, without further constitutional amendment, no fair housing law could be passed and no local agency could take any step to abolish or interfere with racial discrimination in housing. The law was couched in apparently neutral terms, but because of its obvious effect in encouraging racial discrimination, the Supreme Court concluded that it was invalid state involvement in racial discrimination. There was no evidence whatever in that case that the particular seller who was involved would not have discriminated but for this statute, but for this constitutional amendment. But the amendment made that discrimination lawful in California. It encouraged that discrimination, so the Supreme Court held it invalid. Probably the best way doctrinally of explaining the Reitman case is to view it as an impediment that the state imposed to one particular kind of legislation. The state made it harder to pass fair housing laws than any other kind of law. That was the sense in which the state discriminated, although it appeared to be acting in a neutral way to protect someone's right to decide to whom to sell. It made it harder to pass that kind of law. That was discrimination against Negroes. Nor could it be justified on the ground that this is a particularly volatile area in which it's appropriate that laws be harder to pass. Because if that justification were permitted, then school segregation or any kind of segregation could be justified on the ground that this is a particularly volatile area, let's not rock the boat. Well, that hasn't been accepted by the court, and so that has been deemed impermissible state involvement in discrimination. Items 1 and 5, the primary election cases and the state delegation cases, this is on page 23, are both manifestations of a broader category of public function cases. Whenever something is done by a nominally private party, but performs an important public function, like the function of holding an election, a primary election, which is an integral part of the state's elective process, or the function of running a town, that's what Marshville, Alabama involved, running a company town. The function is ordinarily run by the state. then the mere fact that the state has permitted a private individual to run it in this instance does not mean that that private individual can, with impunity, do what the state itself could not do. In Marsh v. Alabama, the court held that the nominally private owner of a company town could not exclude people who wanted to distribute religious literature. The First Amendment is a prohibition directly only on Congress. Indirectly, through the 14th Amendment, it's a prohibition on the states. It's not a prohibition on private action, but the court said this wasn't private action because this was a public function. Running a town is a governmental function. The same thing was true in the primary cases, the election primaries. The 15th Amendment itself speaks only to state action. But when the state permits private parties to run an integral part of the election process, they too will be subject to state requirements. Governmental administration of a program can impermissibly involve the state in racial discrimination. One of the most important cases in that area was the Girard College case in 1957. A trust fund was set up for a school for white orphans only. And the city of Philadelphia acted as trustee for the fund. The Supreme Court held that even though the original discriminatory motive didn't belong to the city of Philadelphia, but the person who set up the trust fund, nonetheless the city couldn't involve itself in discriminatorily administering the fund. So the public trustees had to relinquish control. Incidentally, what happened in that case was that private trustees were appointed, but the private trustees continued to maintain very close contact with the Philadelphia Orphans Court, and the court took a special interest in the administration of the fund and awarded special citations to the college. And the federal courts recently held that the mere appointment of private trustees didn't purge the activity of impermissible state involvement, and the Supreme Court denied certiorari. There's another important case in this area, Burton v. Parking Authority, 1961. That's a case where a city leased part of a public garage to a restaurant. And the restaurant excluded Negroes. Although the owner of the restaurant was a perfectly private party, the financial involvement between him and the state was thought to be enough to implicate the state in prohibited action. One of the most important cases is a recent one which is conceivably ripe for the bar about now. It's Evans versus Newton, 1966. In that case, there was a park that was left in Macon, Georgia, for whites only, and it was run by the city. Well, obviously that wouldn't pass muster under the Girard College case, and so the city got rid of the public administration and appointed a bunch of private people to act as trustees of the trust fund and to operate the park. But city employees still trimmed the bushes and took care of the park in a great many ways, and the park was performing largely a public function, like that of elections, like that of a city. The public generally used it. Only Negroes couldn't use it. The Supreme Court concluded that a combination of all of these factors, the involvement of city officials, the public function, the obvious deliberate replacement of public trustees with private trustees to avoid the equal protection claim, all of these things impermissibly implicated the state in racial discrimination. Negroes would have to be admitted to the park. An unsettled question in that case, by the way, is what would happen if the park would revert to the heirs of the person who originally established the trust fund on the ground that his racially discriminatory purpose could no longer be carried out. If that all happened without any involvement of any state agency, probably no equal protection issue would arise, but it's unlikely that no state agency would be involved. Probably some private party would challenge it in the courts, someone would refuse to leave the park. As soon as a state agency had lent its support to the enforcement of the reversion, it's conceivable that prohibited state action would be found. At this point, why don't you turn to question 21. This is March 1960. B, a real estate broker, accepted a listing of real property for sale to Caucasians only. He knowingly negotiated a sale to a non-Caucasian, representing to the vendor that the purchaser was Caucasian. A complaint was filed with the State X Real Estate Commission, a state agency having quasi-judicial powers, requesting suspension of B's license on the ground that his actions constituted a violation of the State X Real Estate License Statute. B filed a motion to dismiss the complaint for insufficiency. What decision? Give reasons. This is not nearly as easy a question as it seems. To begin with, the answer really ought to turn on what the State X real estate license statute provides. Let's suppose that the statute says, no real estate broker shall accept a listing of real property for sale to Caucasians only. Obviously, he could be suspended for that. There would be state action, no doubt about that. But the state action would be in no sense discriminatory. The statute could provide, we don't want people to accept listings for sale to whites only, that's a bad thing, and obviously not discriminating against Negroes by enforcing that. Now, possibility number two, what if the statute says, no one shall knowingly accept a listing of real property for sale to Caucasians only, nor shall anyone who has accepted any listing of any kind breach his fiduciary duty to the seller by violating what he's accepted. He has only two alternatives under the state law. One is to resign, to refuse to consummate the sale, and the other is to abide by the original instructions. Now, what if his license is suspended by the board on that kind of theory, that he violated his fiduciary duty, that of course he should not have continued with this arrangement, but rather than breaching his fiduciary duty, he should have said, I'm sorry, having accepted this thing for sale to whites only, I made a mistake, I'm not going to deal with you any longer. Again, state action, but not at all clear that there would be state discrimination. Another complication in this question is the fact that although there's obviously state involvement, there are conflicting state interests. It is true that suspending this real estate broker's license and suspending the license of anyone else who sells to Negroes in violation of a prior agreement that he's made with a white property owner would make it more difficult for Negroes to purchase property. But it's also true that the state has an interest in enforcing a fiduciary duty. Is the state truly discriminating when it enforces that duty for neutral reasons, assuming it would enforce it upon anyone who broke his agreement? Moreover, this case is not exactly like the leading case in this whole area, Shelley v. Kramer. In Shelley v. Kramer, there was a restrictive covenant, there was a willing seller of property and a willing buyer. The restrictive covenant said no sales to Negroes, but everyone who was around wanted the sale to take place. The seller did and the buyer did in any event. State court said, no, you can't consummate the sale. It enforced the restrictive covenant, though the seller and buyer were willing. It's obviously state action by a state court. The action, the Supreme Court held in Shelley v. Kramer, was discriminatory because but for the state's intervention, this sale would have taken place. Now, in this case, what if, for example, the seller brought a suit for rescission for material misrepresentation, wanted to get the land back? Here we would have not really a willing seller, we'd have a deceived seller and a willing buyer, and conceivably Shelley v. Kramer would be distinguished. It's true that in this case we don't have a suit for rescission. We have an attempt by the state, through one of its agencies, the Real Estate Licensing Commission, to penalize somebody, and conceivably that would make the court treat it more like Shelley v. Kramer than like the case of the seller who seeks rescission. One other point. Let's suppose that the Real Estate Commission does not dismiss. Let's suppose it suspends the statute. What sort of judicial relief might be available? Could this man get a hearing in a federal court? Well, one of the only ways in which the judicial power section of the outline is ever implicated is this way. For you to see in a case like this that there may be some problem with someone standing in federal court to assert a constitutional right that you're talking about in your answer. Here, if you conclude that the complaint should be dismissed, it's because of the constitutional rights of prospective Negro buyers, not the constitutional right of the real estate commission, not the constitutional right of the real estate broker himself. The ordinary doctrine is that at least in a federal court he must assert his own rights, not those of a third party. But remember that exception, Barrows v. Jackson. That's where a white seller was allowed to resist paying damages for breach of a racially restrictive covenant. Although the rights were those of prospective Negro buyers, the court thought that unless he could assert those rights, there would be no one who could effectively assert them. And the same would probably be concluded here. The standing issue would probably be resolved in his favor on the authority of Barrows v. Jackson. Okay. Item 4, to whom do the individual guarantees of the Constitution apply? Well, they ordinarily apply to everybody. People, citizens, even aliens, when they're in the country, are deemed persons, obviously. But occasionally the word citizen is used, and when it is used, in particular when it's used in the privileges and immunities clauses, it means only individual, natural person. It does not mean a corporation. So that a corporation is not entitled to the protection of either of the privileges and immunities clauses. Note also the Fifth Amendment privilege against self-incrimination applies only to natural persons, not to corporations. And an aside that I want to note here, because I neglected to put it in the criminal procedure outline, but it may be important, one may not assert the Fifth Amendment privilege of another. That is, if something is obtained in violation of X's privilege against self-incrimination, and it's used against Y cannot complain of it. The Fourth Amendment, unlike the Fifth, does apply to corporations as well as natural persons. The due process and equal protection clauses apply to all persons and all corporations, including aliens and foreign corporations in this country. All right. Item B, retroactive legislation, a topic that comes up fairly often in the bar. It takes various forms: impairments of contract, ex post facto laws, bills of attainder, and retroactive laws that don't fall in any of those categories but are so extreme in their operation as to be deemed violations of due process. Most frequent on the bar of all of these is the impairment clause. No state shall pass any law impairing the obligation of contracts. Notice it says no state. Does not apply to the federal government. Retroactive federal legislation that attempts to undo rights that have already vested under a prior contract may be invalid under the due process clause of the Fifth Amendment, but not under the impairment clause. Note also the provision applies to any law, and the court has held that that means any piece of legislation. A judicial decision cannot violate, however retroactive or unexpected it may be, cannot violate the impairment of contract clause. The only kind of legislation to which this clause relates is legislation which deprives someone of substantive rights under a contract, either an executed or an executory contract, not legislation which simply alters the remedy for enforcement of the contract. A typical bar exam question will involve a contract claim with a sudden legislative change in the applicable statute of limitations, so that a claim that appeared to be dead is suddenly revived, or a claim that was going to last for 5 years is suddenly extinguished. Both of these are deemed to be simply changes in the remedy and are not substantial impairments of the obligation of contracts. They're perfectly all right. Now notice that contracts in this clause applies to public as well as private contracts. State charters, agreements between the state and private individuals, all of these are covered, but they are all treated in a rather special way by the Supreme Court. Number one, it's important to remember that most state constitutions, I think all, reserve to the state the power to revoke, alter, or amend any of its own charters or contract agreements with private individuals. So for all practical purposes, if the contract is with a state can, with relative impunity, change it without violating the impairment clause. Number two, whenever you're dealing with a public contract, rather than holding that a piece of state legislation has invalidly impaired the obligation of that contract, the Supreme Court is likely, if at all possible, to construe that contract in favor of the state if there's any ambiguity. Number three, there's a general rule that a state cannot bargain away its power to enact regulatory legislation or its power of eminent domain, so that somebody cannot come in and say, you can't validly apply this regulation to me because some contract that I have with the state immunizes me from future state regulation. That kind of argument has uniformly been rejected. However, the cases hold that the state can bargain away its power to tax. If the state has a contract with a corporation or an individual granting him a tax exemption of some kind, it cannot later abrogate that agreement, unless, of course, it comes within a state constitutional clause saying the state can revoke or modify that exemption at a future time. Item 2, ex post facto laws. When you have time, you might look in the back of the outline on question 34. Loyalty oaths may sometimes be deemed invalid under the ex post facto clause. This clause, unlike the impairment of obligation clause, applies both to the national government and the states. Both are prohibited from passing an ex post facto law. But An ex post facto law is not just any law which operates retroactively. It must be a law which either creates a new criminal punishment for an act that was not criminal when it was done, or a law that increases the severity of criminal punishment for a crime after the crime has been committed, or a law that reduces the amount of evidence or burden of proof necessary to prove guilt for that crime after the crime was committed. Remember, deportation is not deemed punishment for purposes of the ex post facto clause. Also, the fact that the state has legislated with respect to past criminals does not mean that it's suddenly making conduct a crime. The Supreme Court has held, for example, that the state may provide that in the future no felon may take part in a given election or hold a particular kind of office. This is not thought to be imposing a new punishment on persons for prior conduct. It's thought simply to be imposing a generally valid regulation based upon facts that are taken from the past as well as the present. The distinction becomes a rather artificial one, particularly in the area of bills of attainder, where again both the national and state governments are barred from enacting them. Now, historically, all bills of attainder included were pieces of legislation that specifically named individuals and either banished them or sentenced them to death, or said that from then on neither they nor their children nor anyone tainted of their blood shall inherit property. This was the historic origin, but it's been vastly broadened by the Supreme Court. I mentioned the case of U.S. v. Brown, where the court held that it was an invalid bill of attainder to provide that communists could not hold office in labor unions. An attempt to draw lines in this area is very difficult. The usual idea is that although the legislature may provide some kind of a shorthand description of people so that it short-circuits the need for trial, for example, in conflict of interest laws, it needn't say anyone who is found by the courts to have a conflict of interest in two positions can't hold both positions. It can just establish legislative presumptions that all people who are members of X industry can't serve on Y board because there's an inherent conflict there. When that's done, the court has upheld that. Some might have thought that Brown v. U.S. was exactly like that. The distinction is hard to draw, but just be familiar with that case. Finally, there's the residual due process clause. Even if something doesn't violate the previous provisions, it's truly extreme, it'll be deemed a violation of due process. For example, although it is not a violation of due process to revive a previously dead cause of action, it's deemed just a change in remedy, not of substantive vested rights, nonetheless, to tax retroactively a gift that was made in the past and that was at that time not subject to taxation is deemed a violation of the Fifth Amendment due process clause. Okay, page 26, limitations on the power of eminent domain. The Fifth Amendment provides that private property shall not be taken for public use without just compensation. This is not a grant of power. Congress must find somewhere else its power to take the private property. It must be ancillary to some other exercise of Congress's power. Commerce power, or the power to control post offices, might be a power that justifies condemning property on which to build a post office. But unless there is some other source of the power, the Fifth Amendment's just compensation provision does not in itself affirmatively authorize Congress to do anything. Rather, it imposes limitations. It imposes two limitations. First, that there must be just compensation, and second, that the land must be taken for public use. Of course, whether it's taken for public use or not is largely a question of policy judgment that the courts are not going to review. Now, this restriction, that that the government not take property and then not pay the owner for it, is applicable to the states as well as the federal government. Court held in a very early case in 1896 that to take private property for public use without any compensation at all is to take it without due process of law, and therefore it's something the states cannot do. We'll discuss that a little more later on in the outline. Item 3, well, this is later on in the outline. What constitutes a taking? What constitutes a taking besides formal condemnation? I mean, very often the problem on a bar exam question will not be whether compensation is or is not sufficient. The problem will be, has anything been taken? General doctrine is the government need not compensate for injury that's done to property. One must be able to find some concrete property interest, like an easement that has been taken. In U.S. v. Cosby, for example, where planes belonging to the U.S. government flew very low over some guy's chicken farm and virtually ruined its value, the court's approach was not to say that the value was ruined, the land was injured, in effect his property has been taken, he must be paid. No, they had to find a property interest, an easement in the air over the land that had been taken. That was why he was entitled to compensation. So the analysis here is rather mechanical. You've got to identify a specific interest in property that's been taken. Note also that if property is destroyed rather than taken for public use, and if it is destroyed because of some national emergency or some paramount kind of overriding policy, although one might suspect that because the land is destroyed in the public interest that the public ought to pay through the general revenue, that is not the doctrine. The doctrine is that if it's taken as a necessity of war or flood or emergency, the government confiscates somebody's land, it's his tough luck. He, and not the public, must bear the loss. In U.S. v. Caltex, for example, the Army destroyed an oil refinery in the Philippines to prevent it from falling into the hands of the Japanese. The owner of the refinery sought compensation. The court said there was no taking. This was just one of the fortunes of war. Regulations that impair the use or value of property, namely primarily zoning regulations, even if they make the property almost worthless, are likely not to be deemed a taking. They're likely to be deemed just regulation, no right to compensation. With respect to compensation, note that whether or not an amount of compensation is just depends upon the value of the property when it's taken, not how valuable the property becomes to the government after it's taken it. All right, item D, substantive due process of law. You're interested in several things here. We're interested in the reasonableness in the purpose, the method, and the impact of governmental action. In the 1920s and 1930s, all kinds of state regulation were held invalid by the U.S. Supreme Court on a general theory that it wasn't reasonable, that it seemed arbitrary, that it deprived people of something that the court called the liberty of contract. The Supreme Court struck down minimum wage laws, child labor laws. This is not an area in which the court has been active lately. For the past 30 years, the court has not acted in this area. Substantive due process of law is dead insofar as business and economic issues are concerned. It remains alive in some limited areas. There are at least two old substantive due process of law cases that would probably be decided the same way today, but on different grounds. One case held invalid a statewide prohibition against the teaching of German in public or private schools. Another struck down a state ban on private school education. The court held, on a kind of substantive due process analysis, that you couldn't abolish all private schools and you couldn't abolish the teaching of a foreign language in all of the schools. Those cases would probably be decided the same way now, but on the ground that such abolitions were violations of freedom of expression as protected by the First Amendment. Note also that in any case of business or economic regulation on the bar, you will often have, in addition to the federal substantive due process issue, which can be dealt with rather briefly by pointing out that it was an area that the court used to deal with rather strictly but is now extremely liberal in, you'll also have often state constitutional law issues. The Illinois Constitution bans certain kinds of special interest legislation. Article 4, Section 22 of the Illinois Constitution. And when you're reviewing for the bar, you might look, without looking at any detail, in the answers given in the outline to questions 27, 32, 37, 56, and 59. All of these questions involve the Illinois special legislation provision, and a great many states have similar provisions. Also, a great many, and the provision is described in the answers to those questions, a great many states impose fairly rigid requirements upon delegations of power. The Supreme Court would not hold that a state delegation of power to a licensing board or an agency is void because it's too broad a delegation. But state courts, including that of Illinois, would so hold if no standards whatever accompany the delegation. We have several minutes left, and rather than leaving early, I want to continue because otherwise we're going to have to stay over later on. We have to cover the entire criminal procedure outline tomorrow in addition to the First Amendment. State action which interferes with constitutionally protected rights like speech, press, religion, assembly, and the right to petition. This is the top of page 28. State action which interferes with these constitutionally protected rights is not treated with the same solicitude as is state business and economic regulation by the Supreme Court. Such action is subject to very close scrutiny. It's subject first to scrutiny under the Equal Protection Clause. Now, the Equal Protection Clause of the 14th Amendment does not apply to the federal government. No state shall deprive any person within its jurisdiction of the equal protection of the laws. However, if federal action discriminates against certain individuals on obviously impermissible grounds, like grounds of race, the Supreme Court will hold it invalid as a deprivation of liberty without due process of law under the Fifth Amendment. so that for practical purposes it doesn't matter a great deal that there is no equal protection clause that restricts the activities of the federal government. Now, discrimination as such in legislation is not unlawful on its face. Obviously, statutes must draw all kinds of lines, and many of them must be relatively arbitrary ones. The accustomed doctrine is that simply because a legislature has decided to solve part of a problem now and leave the rest for the future, the mere fact of under-inclusion, that it's included some categories but not others, that is not in itself a reason to invalidate the legislation. Nor is it a reason to invalidate legislation that it may draw a fairly arbitrary line. For example, one might well say that a line saying that people under 18 cannot vote, those over 18 can, is arbitrary. Of course, wherever that line is drawn, it will be arbitrary as applied to some individuals. But as long as age is recognized as a rational criterion for determining this kind of thing, then the fact that the line itself, the placement of the line, is arbitrary makes no difference. There are, however, three basic criteria that must be met with respect to legislation when it's challenged under the Equal Protection Clause. First, the classification must not be invidious. There are certain classifications in terms of race, in terms of nationality, that the Supreme Court traditionally holds are impermissible. And it's virtually impossible to conceive any such classification apart for purposes of the census or something that the court would deem rational. Number two, whatever the classification, it must be rationally related to some legitimate legislative purpose. I mean, something that said all blue-eyed individuals, as opposed to green-eyed individuals, must pay $3 extra in taxation would be held invalid under the Equal Protection Clause. No conceivable reason for drawing a line in that direction. Number three, the classification must not result in an arbitrary deprivation of fundamental rights, even if the line itself is all right for other purposes. If the consequences are too grave, the line will be invalidated. The best example of that is the one given in the outline, Skinner v. Oklahoma, where it was provided that somebody who's guilty of larceny by false pretenses goes to jail. Somebody who is guilty of embezzlement is sterilized. The U.S. Supreme Court held, not surprisingly, that that is a violation of equal protection, although to impose heavier punishment on embezzlers would not be held invalid. Okay. See you tomorrow.